ठीक। हाँ जी। Hello, check. Hello, 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 check. Hello, hello, check.
Hello, hello. Morning, everyone. May I request all of you to please put your phone on silent? The guests are about to arrive. Please, I request everyone to please put your phone on silent. Hello, hello. Hello. Good morning, ladies and gentlemen, respected dignitaries, distinguished guests, faculty members, participants, and dear students. I, Pooja Kyawat, on behalf of National Law Institute, University Bhopal, welcome all of you to the inaugural session of the International Conference on Echoes of Bhopal Gas Tragedy, 4 decades of reckoning and lessons for the future, being organized by NLIU Bhopal in collaboration with National Disaster Management Authority, Nalsar University of Law Hyderabad, and co-sponsored by Indian Council of Social Science Research. This conference seeks to revisit, reflect upon, and reimagine the lessons from one of the most significant disasters in history and to collectively explore the path towards justice, accountability, and resilience. To mark the auspicious beginning of today's session, may I now invite our esteemed dignitaries on the dais to kindly come forward for the lighting of the lamp, a symbol of wisdom, knowledge, and enlightenment. Thank you, esteemed guests. As a gesture of respect and warmth, we extend a floral welcome and present mementos to our distinguished guests. May I request Professor Dr. S. Suryaprakash, Vice Chancellor, NLIU Bhopal, to kindly extend a floral welcome and present a memento to the Chief Guest, Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India. May I request our Vice Chancellor, sir, to do the honors of presenting a floral token of welcome and a memento to the guest of honor, Honorable Mr. Justice Vivek Agrawal. May I request Vice Chancellor, sir, to extend a gesture of welcome by presenting a bouquet and memento to the special guest, Honorable Mr. Justice Vishal Dagat, sir. May I request our Vice Chancellor, sir, to felicitate our distinguished guest, Professor Dr. Sri Krishna Deva Rao, sir, Vice Chancellor, Nalsar University of Law, Hyderabad, with a floral welcome and presentation of memento. May I request Professor Dr. Raka Arya, convener of the conference, to do the honors of presenting a floral token of welcome and memento to Professor Dr. S. Surya Prakash, Vice Chancellor, NLIU Bhopal. I invite ma'am to extend a gesture of welcome by presenting a bouquet to Shri Vivek Bakshi, Registrar, NLIU Bhopal. May I request Professor Dr. Atul Kumar Pandey, Dean Undergraduate Studies, to felicitate Professor Dr. Raka Arya, convener of the conference, with a floral welcome. Thank you, sir. May I now invite Professor Dr. Raka Arya, convener of the conference, to kindly introduce the theme and objective of this international conference. Before, before moving ahead, it is my privilege to share a brief introduction of our esteemed convener. Professor Dr. Professor Dr. Raka Arya Professor of Political Science and Dean Student Welfare at NLIU Bhopal, has been associated with the institution since 2003. She holds a PhD from Jawaharlal Nehru University. Her area of specialization includes political studies, constitution and administrative law, air and space law, and gender and human rights. She currently serves as chairperson of Learning Outcome Based Curriculum Framework UGC Committee on Law and vice president of Indian Political Science Association. Professor Arya was a member of the 22nd Law Commission of India and has been part of several state and national committees on women empowerment, governance, and legal reforms. As a distinguished academic and trainer, she has delivered over 200 lectures and conducted extensive capacity building programs on gender, law, and justice across government departments and legal institutions. We look forward to hearing from you, ma'am.
Thank you, Pooja. Thank you so much. On behalf of NLIU, I extend a very warm welcome to all of you for this conference, international conference on Bhopal gas disaster or tragedy, whatever we call that. Distinguished guests on the dais, faculty members, participants who have come across the country, and the resource persons who have come to participate in this conference for the deliberation for the 2 days, as it is going to have some 6 thematic sessions, as we know. Some 120 of course, papers will be presented in this conference on various themes which are spreading across from the disaster management aspect, the disaster aspect of the Bhopal gas tragedy, the environmental dimension of the Bhopal gas tragedy, the state obligation part, and the CSR part is also there. So we can see that there are multiple themes on which we will be deliberating, taking all kind of dimensions of the tragedy, which you all are aware happened in 1984 in the midnight of 2nd December and 3rd December. And we do know that this particular tragedy, because though we are in the 40th year of this, very soon it will be 41st year, but still we know that there are some aspects which are still not attended, or rather I will say that still we are working upon them to finalize that how these things will be resolved. As you all are aware that this is the worst industrial disaster so far, and we are all aware that as far as the Bhopal gas disaster is concerned, it is very much part of the state's activity of the development, as well as we do say that industry play a very vital role. But then before doing some industrial setup, what all is needed, human life has to be taken into consideration. So development has a human phase as well. It should not be looked over, or it should not be ignored. Both have to work in complementary, and we know that there is an institutional setup to take care of all these aspects, in which of course the state, which includes government as well as judiciary, plays a very, very important role. We do know that civil society groups are also playing a very, very important role. As we have heard about the tragic incident, how did it happen, that how thousands and thousands of people did die because of that ignorance, or rather we can say negligence, if I say something about the legal part as well. Legal negligence on part of some, and disaster for many, which continued, as I said, till present, because there are issues which are arising out of it. So we thought that 40 years, though people thought that it is a long period, to discuss such kind of issues. But the issue is of not that nature that we can say that ended then and there. It was something having after effects also. As you know that on human health, it is having a kind of effect which is still continuing. There may be two opinions. People may be believing that they might be continuing still. There are some who may believe that it may not. So that is the some time for us to find out where exactly the truth is, whether it is in between or it is on one side, that people are having a kind of opinion. So we thought that not only this, that what has happened then, where we have erred, what all have been the mistakes that already been deliberated so many times, but we are just going to learn about that, that what exactly has happened, have we got over it, or still there are some lessons for us to take away from that, so that we can decide our strategy for future as well. So this is something, as I say, a takeaway message also. And it is also a kind of example that has been set for all of us, that whenever there will be such kind of endeavors made by the state, what all precautions we have to take and who all actors that will be involved, and how we can actually circumvent those who may take advantage of the situation, because this tragedy has layers of tragedies. It is not only one tragedy that has happened on the night, but this is something that has followed by multiple tragedies after that particular day that it happened. So this is something we are trying to take a particular kind of stock of the situation, that how these situations will be dealt with. And as we could see, the very first thematic session will be based on disaster management, in which, of course, multiple dimension of disaster management will come there. So for that, of course, the National Disaster Management Authority has agreed to collaborate with us, and the theme is, of course, to an extent dedicated to them. And we will be, of course, having a visitor from NDMA who will be coming in valedictory session. So we will be listening from them. As far as Professor Bartolini is concerned, he is from University of Rome. He is also an expert on disaster management and, of course, taking cognizance of these things. So we are having him administer us. Then we have Professor Michelle, who will be talking us about, and that she will be joining us online. There have been a particular thing that unfortunately she didn't get her visa, so she couldn't make it. Otherwise, she would have been administered us. And she is an expert on the tort law, and she will be speaking on the tortious aspect of the mass disaster. So she will be addressing, of course, in plenary session virtually. And then we are having, as Dr. Pooja has said, that Indian Council of Social Science Research is also co-sponsoring with us. And we have honor of NASA collaborating with us as a university who has joined us in this endeavor to explore all possibilities, how these issues should be handled. And so we do not witness any such kind of disasters in future. And everyone has to play a role. There are a lot many stakeholders in that. So this will be the time that 40 years we are taking a stock. And I would like to, of course, thank Professor S. Surya Prakash, Honorable Vice Chancellor of the university, who has this particular thing very dear to his heart. And of course, I'm just executing what he wanted. And I hope that I rise up to his expectations. And once again, I'll welcome you all on the campus. Thank you so much, and I think technical details will be shared with you, though you all might have got all the program, a copy of program with you. So you can see which technical session you have to attend. You see that today 3 sections will be there. So then whosoever will be presenting paper in whatever theme, they can. Others are most welcome to join in the discussions and deliberations. So nobody is prohibited and stopped from interacting in various sessions. Whatever you find interesting, you can join us. Thank you so much. Once again, welcome on the campus.
Thank you so much, ma'am, for setting the tone for the conference and for guiding us through the vision behind the academic endeavor. Ladies and gentlemen, it is my honor to invite Professor Dr. S. Surya Prakash, Honorable Vice Chancellor, NLIU Bhopal, to deliver the welcome address. But before that, with due honor, I would like to present a brief profile of Sir. With a distinguished academic career spanning over 30 years, Sir has held esteemed positions including Vice Chancellor of DSNLU Vishakhapatnam, Founder Vice Chancellor of NMNLU Aurangabad, and Professor of Law at NLIU Bhopal. A prolific scholar, he has authored and edited number of books and over 35 research articles on critical legal subjects including labor law, arbitration, mediation, and human rights. His work has significantly contributed to legal academia and policy making, with his research influencing judicial reforms and access to justice initiatives. Sir has also represented India internationally, studying the US judicial system under the prestigious International Visitor Leadership Program. His dedication to legal education and research continues to inspire generations of law students and professionals. His area of interest includes jurisprudence, ADR, international commercial arbitration, labor law, health law, and culture and law. Sir, we request you to kindly address the gathering.
Good morning to all. Chief guest for today's program, Honorable Justice Shri Pankaj Mittalji, Judge Supreme Court of India, and the visitor, National Law Institute, University Bhopal. Sir, in spite of your busy schedule, you have given us time, and for which we wholeheartedly welcome to you for this program. Honorable Justice Vivek Agrawalji, Judge, High Court of Madhya Pradesh, Member, General Council, NLI Bhopal, and Shri Justice Vishal Dagatji, Judge, High Court of Madhya Pradesh, and Professor Sri Krishna Deva Rao, Vice Chancellor, Nalsari University of Law, and also a partner in conducting this event of Bhopal gas tragedy commemoration, and Shri Vivek Bakshi, Registrar, and our Dean, Student Welfare, and convener of the program, Professor Dr. Raka Arya, and many of the Vice Chancellors, Professor Bindu Ronald, Vice Chancellor, Maharashtra National University, Aurangabad, Professor K.V.A. Sharma, Vice Chancellor, National University, Assam, friend of NLIU, Sri Vijay Chaudhary ji, and galaxy of academicians, esteemed faculty members, and participants coming from different institutions, and my dear student friends. Generally, we say that it gives me immense pleasure, but in this story, it is not like that. It is a painful review after 40 years. And when this Bhopal gas disaster has happened, and what was our preparedness, and what has changed since these 40 years. So, speaking about Bhopal gas tragedy and how our Indian legal system has handled the matter, to say these things in a few words means compressing an epic into an epigram. But however, within a few minutes, I would like to give an overview of how this has happened, why this has happened, and a brief story about this Bhopal gas tragedy, particularly the juridical anatomy, and how this was handled by our legal system. So ever since the dawn of civilization, development and disasters are going hand in hand. If some disasters are accidental and other are due to human negligence. And this Bhopal gas disaster, it was due to human negligence because of the human greed. Whereas the accidents may be pardonable, we may excuse the accidents, but the later disasters due to negligence are not. The Bhopal gas disaster belongs to the second category, and for many lakhs of Bhopal gas victims, the invaluable right to life has been denied to them. When they were in deep sleep, some of them, they left to the heavenly abode without their knowledge and without their notice. And just I would like to, because we have studied, read in the newspapers that this is an MNC, multinational company. What is the relevance? Why we are suing this in the Indian courts, etc., etc. Again, I am in dilemma whether to say it is fortunate or unfortunate. I got the opportunity to teach this paper of mass starts at NLIU Bhopal. So I gained some knowledge and information about this Bhopal gas tragedy. So the Union Carbide of India Limited was established in the year 1969 near Bhopal with 50.9% owned by Union Carbide Corporation. So the majority shareholders, 50.9%, it was by the Union Carbide Corporation of USA, and only 49.1% by the Indian investors, including public sector institutions and the private individuals. That means the UCIL, Union Carbide India Limited, majority shareholders, it is the UCC, that is the foreign company, not the Indian owned company. And it produced pesticide carbon servin, that is In 1979, methyl isocyanate, that is MIC production plant was added to this site. So the most dangerous gas, which was responsible for thousands of deaths, it was started in 1979, and it was used instead of less hazardous but more expensive materials. And UCC, that is Union Carbide Corporation, it is understood that they are aware of the most dangerous chemicals properties that are handled by it. And now, coming back directly to the intervening night between 2nd and 3rd of December 1984, what has happened? The Bhopal gas disaster or Bhopal gas tragedy was an industrial disaster that took place at the Union Carbide pesticide plant in the Indian city of Bhopal, Madhya Pradesh. During the night of December 2nd and 3rd, 1984, large amounts of water entered into the tank 610 containing 42 tons of methyl isocyanate, and the resulting reaction increased the temperature inside the tank to over 200 degrees Celsius, that is 392 degrees Fahrenheit, raising the pressure to a level the tank was not designed to withstand. This forced the emergency venting of pressure from MIC holding the tank, releasing large volume of toxic gases. That is, this methyl isocyanate, when it is mixed with water, this was a very deadly cocktail, and the lid of the tank was blown off and the poisonous gas entered into the atmosphere. And what has happened? A mixture of poisonous gases flooded the city of Bhopal, causing great panic as people woke up with a burning sensation in their lungs. At midnight, more than 5 lakh people were exposed to MIC and other chemicals to the accidental release by the Union Carbide factory. The people who woke up in the midnight due to poisonous gas with eyes and lungs burning hundreds and thousands, they started ran crying and screaming to save their lives. And in the midnight, they woke up, they do not know what has happened, they started running and crying, and while running, they started inhaling more and more poisonous gas, which has directly affected their lungs. More they ran, more they inhaled the poisonous gas only to suffocate and impacted on the nervous system, lost control on their bodies. The darkness coupled with burned tissues of the eyes, temporary blindness, and could not understand what has happened. The factory emergency siren has been switched off. When the plant manager woken up about 1:30 a.m., the official information reached to the police at 3 a.m., saying that the leak has been plugged off. At 4:30, the manager informed the reporters that their safety measures are best in the world. In fact, there was no gas and tank has become empty. There was no more poisonous gas left in the tank. The poisonous cloud stayed for 2 hours on the city of Bhopal, caused enormous damage to the environment, livestock, and human lives. Thousands, they died immediately. Thousands of innocent citizens of Bhopal, they died without knowing that they are dying. And the first immediate death toll was 2,259. The government of Madhya Pradesh has confirmed 3,787 deaths to the gas release immediately within 2 days. And others estimate that 8 to 10,000 people, they died within 2 days, within 72 hours. And more than, till today, more than 40,000 has died due to this poisonous gas, and the counting is still going on. This is what has happened on the intervening night of 2nd and 3rd December. And there is a lot of description, but due to paucity of time. and how our legal system and Dominic Lapere, Freedom at Midnight, 5 past midnight, they said that there was, because during that time, there was this militancy in Punjab. There was a turban person. It may be a sabotage by the Sikh militants. And all these theories, they have been propagated. Thanks to the then CJM, Chief Judicial Magistrate, Mohan P. Tiwari, finally who has delivered the judgment on Bhopal gas tragedy. He was the Chief Judicial Magistrate on 7th June 2009. He delivered the judgment, and the findings of the CBI revealed that it was the greed of the UCC. And all the safety measures, they failed on that day. Because if there is any leakage of gas, that could be burnt out. That tower was under repair, and many other, all the safety measures, they failed on that day. And it was how water entered into the tank 601. It was as a part of maintenance. The workers, they have been cleaning the pipes and everything, and in the joints of the pipes, there were some cleavages, and through those cleavages, the water entered through the pipes, and finally, it went into the tank 610, where this methyl isocyanate was stored. And the cocktail of water and methyl isocyanate has, at 200 degrees Celsius, has blown the lid. And what was the response of our Indian legal system? So initially, the government of India has passed this Bhopal Gas Disaster Processing of Claims Act 1985, and just I will quickly go through. We have filed for 5 billion compensation in the District Court of New York, and lot of arguments took place. And one Professor Mark Galanter of Wisconsin University, earlier he was here, and he helped the government of India in preparing the petition. And there all kinds of nasty arguments also took place, how in the court, the lawyers, US attorneys, they have compared Indian citizens as insects and so many things. Finally, the whole matter was shifted to India on this forum non-convenience, and the matter was taken up at the courts in state of Madhya Pradesh. So since the first India filed a complaint in 1985, when the matter returned to the District Court of Bhopal, so in the initial days, 350 crores interim relief was granted by the District Court of Bhopal. But however, this was challenged by the UCC in the Madhya Pradesh High Court, and again the matter, it went to the Supreme Court. Like that, a lot of litigation took place. As I said, that the act was also challenged, and to quote in the words of my beloved teacher, Professor N.R. Madhav Menon, at the end of the day, the Supreme Court of India has brokered, the word not used by me, by Professor Madhav Menon. The Supreme Court of India has brokered the settlement, and many NGOs earlier, they were here, Dr. Jayaprakash, Abdul Jabbar, and till afternoon, the arguments went on very vehemently on both sides by the government of India and for the Bhopal gas victims. And in the post-lunch, a deal was struck, and it is popularly known as judicial settlement, and where we claimed for $5 billion US, and finally we settled with 470 million US, which was converted into, in those days, something around 740, 750 crores as compensation. And the then Chief Justice of India, Justice Harith Pathak, after this judgment, he was elevated to the International Court of Justice. I am not connecting the dots, just I am only explaining the facts. So he demitted the office, and on 18th June 1989 and elevated to. So these are facts on record. So what interesting is that all of you may look into the judicial settlement last paragraph. The noted legal luminary who successfully defended the Union Carbide India Limited, the great Fali S. Nariman, successfully defended the MNC, successfully defended Warren Anderson and Associates. Last paragraph it is where he has claimed immunity. So in further there should not be any complaints or petitions in any court, either in India or in any tribunal, either in India or abroad, against anyone, including the advocate. That means including himself, no one should in future make any petition or complaint against in any forum of the world, if possible even in the universe, anywhere in other planets also. So it is very interesting to read the last paragraph. So this is how I can say that justice was denied to the Bhopal gas victims. In the words of Honorable Justice J.S. Verma, what was given to the Bhopal gas victims, it was only peanuts. It was only peanuts. And they were acquitted from all kinds of civil and criminal proceedings. And interestingly, Justice Venkatachalaya, who happened to be one of the judges in 1989 judicial settlement, later on the criminal proceedings were restored. And when it was challenged by one of the NGOs, Mr. Dr. Jay Prakash, he was also here, and without hearing, hardly within 5 minutes, the petition was dismissed. And when Bhopal Gas Memorial Trust Hospital was established, Justice A.M. Mohammadi, he became the first chairman of the Bhopal Gas Memorial Trust. Gee, these are facts, I am not connecting the dots. So things how has happened. But the thing is that finally, this Anderson, the corporate killer, who visited on the second day after this Bhopal gas tragedy, and he was staying in the Union Carbide guest house at Siamla Hills. And some unknown, powerful call has come, and immediately Didan SP, this is available even on the YouTube. The SP during those days, Mr. Swaraj Puri, he gave him a lift, drove the car himself from, because when the people, they learned that this Anderson, corporate killer, he was in the guest house in Siamla Hills, the mob started running towards this guest house, and immediately he was saved and he was put in the aircraft, and he was made to leave the soil, shores of India, and he never returned. And our courts, they sent the arrest warrants many a times, and we know finally what has happened. The CJM of Bhopal, and in the year 7th June 2010, the court has delivered its verdict convicting the 7 officers, executives of the Union Carbide, and all the 7, they were released on the same day on bail. And Mr. Anderson, Warren Anderson, the chairman of this UCC, he was never brought to justice. And when the question was put to the then law minister or someone, sir, why you are not arresting, sending an arrest, unable to arrest this Anderson? I remember that the reply was, we do not know the address of Anderson to execute the warrant. Next day, Indian Express, in the front page, published a story with, here is the address of Anderson. His photograph is home and where he is living, everything, but our system. But today I can proudly say that India, what was in 1984 and 2025, there is a sea change. Today, US can't do like this. But what has happened, we can only pray that this kind of industrial disasters, man-made disasters. So this methyl isocyanate, it should be kept in the -°C and in order to save the electricity bills, the management has turned off the electricity refrigeration unit just to save some $30 to $50 of electricity bills. So this is an amplified version of human greed of the corporate, just to save the money. They do not mind the lives of the innocent citizens. The loss was very, very enormous, and still we visited the Bhopal gas, that Union Carbide factory, and also Bhopal gas, and those young girls who are 5 years, 7 years of age, now they become adults, and when the reproduction system has failed, and when they're delivering the child with the enormous physical disabilities, and we can see in Bhopal Memorial Hospital and all these things. And I congratulate Professor Dr. Rakaria and her team to take up this, because being the law university, that particularly situated in Bhopal, at least this is our responsibility, at least to make a review what has happened, and to suggest the government that tomorrow such things should not happen, not only in India but also anywhere in the world. The legal system should be equipped with such measures that this should not be repeated anywhere in the world. With these few words, I welcome all the delegates and hope that we can have a thorough review, a revision of what has happened, including in the Indian legal system. We can make some good proposals to the government. So in future, such things should not happen. And thank you for your patient listening. Thank you very much.
Thank you, sir, for your enlightening words and for steering NLIU towards academic excellence and social responsibility. May I now request our distinguished guest, Professor Dr. Sri Krishna Deva Rao, sir, Honorable Vice Chancellor, Nalsar University of Law, Hyderabad, to deliver his address. But before that, I would share a brief introduction for our distinguished guests. Sir is the Vice Chancellor of Nalsar University of Law, Hyderabad, and one of India's foremost legal educator and institutional leaders. Prior to joining Nalsar, he served as Vice Chancellor of NLU Delhi and NLU Odisha, with an academic career spanning over 3 decades across India's top law institutions, including NLS Bangalore, GNLU Gandhinagar, and Nalsar Hyderabad. A Fulbright Nehru Scholar, Professor Rao has been a visiting fellow at both University of Washington, Seattle, and SOAS University of London. Professor Rao, his outstanding contribution has widely recognized, including with the Kumarappa Reckless Award, India's highest honor in criminology, awarded by the Indian Society of Criminology in 2020. He continues to serve as a member of the Delhi State Legal Service Authority and was part of Indian delegation presenting India's Universal Periodic Review at UN Human Rights Council in Geneva in 2022. His visionary leadership has shaped legal education, access to justice, and reform in criminal justice system across India. We look forward to hearing from you, sir.
Honorable Justice Pankaj Mittalji, Visitor of NLIU Bhopal, Judge Supreme Court of India, Honorable Justice Sanjeev Sajjawaji, Chief Justice High Court of Madhya Pradesh and Chancellor NLIU Bhopal, Justice Vivek Agarwal, Justice Vishal, Professor Surya Prakash, my old friend, Vice Chancellor of NLIU Bhopal, Professor K.V.S. Sharma, Professor Bindu Ronald, and longtime friend Raka Arya, and invitees, friends, and students. 40 years of a test case litigation definitely requires a review, introspection, and learning from the lessons for the future. There's a lot of difference between 1980s and 2020s. We know, all of us, not just only globalization, trade negotiations, law technology, artificial intelligence, and the new global sustainable development goals. I think this requires. In that reason, I appreciate Professor Surya Prakash and Raka Arya, NLIU Bhopal, taking the lead, being located in the Bhopal. Look at once again. You know, all of us in the law schools, we follow American case method. That's the best method of learning the law. Thanks to Delhi University, Professor Meenan, Banaras Hindu University, many people borrowed and implemented and creatively, imaginatively using as a pedagogical tool in learning. But Bhopal gas case still requires, I think, all of us, once again, we have to read. Read from the beginning, as a comprehensive review has been given by Professor Surya Prakash, to the, when the curative petition was dismissed by Justice Kaul's bench. I think that requires, and look at the comparative. That's what we say, challenge the judgment. Look at the comparative jurisprudence. In that case, I think this requires a lot of curious, intelligent, reasonable minds, all of us we should look at. Of course, we would be happy to create more good course material, teaching and learning materials, maybe a online course or a video we should look at. We will do that. With that purpose, when Professor Surya Prakash asked me that they are organizing international conference, I jumped into. I said we wanted to be partners. I have started as a teacher of torts with Professor Madhav Menon in the National Law School, Bangalore, 1990. So I have a lot of interest in that. So Raka Arya said, multiple tragedies. True, not one simple tragedy which happened in the midnight of 2nd December 1984. Multiple tragedies. Justice Krishna here appropriately called his Boposhima. He knows, he's a wordsmith. Catastrophe, lethal litigation, man-made mass disaster. But for all of us, we need to look at the test case litigation. And how do we learn? Lastly, I will just, two things I wanted to say. One is you look at the amazing environmental law jurisprudence built up. Started with oleum gas leak. You know, Justice Bhagavati, you must read the judgment, 1985 Sri Ram Fertilizer. How he creatively, imaginatively brought a private corporation under Article 32 jurisdiction. And similarly, still unanswered questions is, where is the mechanism for compensation, measurement of the compensation? Mass disaster like this, motor vehicle accident, custodial death, several other things. Where is that? How do we borrow? So that's still a valid environmental jurisprudence. Environmental public hearing. As a public interest lawyer, I was very happy. Where it is gone? Where is that environmental public hearing? So many things are revolving around multiple stories we need to build, understand, engage, and critically analyze. I think that's where. You look at amicus curiae, expert witnesses. It all started. I would say the real social action litigation is Bhopal case. All others are, Professor Bakshi calls, it's not public interest litigation, social action, but this is a real social action litigation. Lastly, I'll just say, what do we learn from here? What does Bhopal teach the world for the future? Firstly, it underscores that the cost of corporate and regulatory negligence is measured not just in lives lost, but in suffering of the entire generation. We look at the human beings. Second, it warns that accountability must cross borders and the pursuit of profit can never overshadow the duty to protect life and environment. Professor Surya Prakash memorably underscored that human greed. Thirdly, it highlights the necessity of establishing and enforcing robust safety regulations, maintaining vigilant oversight, and fostering a culture of transparency and public participation in industrial and environmental matters. Further, it reminds the governments to prioritize risk mitigation, national disaster management, emergency preparedness, and the strengthening of public health system. Lastly, it calls upon corporations to adopt highest global safety standards everywhere, not just where regulations are strongest. Most importantly, Bhopal teaches us the real safety lies not in laws on paper, but in their uncompromising implementation, continuous vigilance, and unwavering commitment to the sanctity of human life and dignity. Thank you.
Thank you, sir, for your valuable insight. Today, we have with us special guest, Honorable Mr. Justice Vishal Dhagaji. Allow me to present a brief introduction of our special guest. Sir was born on 14 December 1969 at Debugra, Assam. He completed his BA Honours from Venkateshwara College, University of Delhi in 1990 and obtained his LLB degree from Law College affiliated to Dr. Hari Singh Gaur University, Sagar. He was enrolled as an advocate with Bar Council of Madhya Pradesh and commenced his legal practice at the principal seat of High Court of Madhya Pradesh, Jabalpur. During his distinguished legal career, Justice Dhagat practiced extensively in civil law, criminal law, revenue law, and on the writ side, covering diverse branches of law, including constitutional and service law. He also served as a government lawyer for the state of Madhya Pradesh, representing the state in various important legal matters and contributing significantly to the administration of justice. In recognition of his professional excellence and integrity, Mr. Vishal Dhagat was elevated as a judge of the High Court of Madhya Pradesh on 27th May 2019. I invite Sir to kindly address the gathering.
Good morning to all the participants, Honorable Justice Mittal, Judge Supreme Court of India, Vivek Agrawal ji, Vice Chancellor, Registrar NLU, and all dignitaries present on the dais and off the dais. We are here to do introspection regarding Bhopal gas tragedy, what happened 40 years ago. So, Vice Chancellors, I heard speaking here that India has changed. It is 40 years since tragedy and there is lot of change in India. But to my view, nothing has changed in India. We are the same people. India, what is India? We the people make this nation and none of us has changed since last 40 years. Why I say so? Tragedies are still happening. Air bus fell, medical student died, cough syrups, children dying. Then we see corona tragedy, medicines again given, injections given, they are just waters. We are most negligent people. We cannot blame our system. We cannot say legislature is bad. We cannot say executive is bad. We cannot say judiciary is bad. There are laws, industrial laws are there, labor laws are there, safety laws are there. So legislature has made all the laws. We, the people of India, has given such a wonderful constitution to our nation. But it is we, the people, who has to enforce it. Person behind the desk is still the same. Computer has come on his table, register has gone, laptops are there, but system has not changed. System is still the same, and it is only the people of India who can change this system, and we are not working for change of the system. We are most negligent people in the world. Our reaction time is slow in India. We react very slowly to things. Roads are bad, we don't care about it. Drains are there, we don't worry about it. Overflowing, pollution is there. We are living in gas chambers. Only we are worried about ourselves. We are not worried about the surroundings. We are not worried about the people who are living uh, in our neighborhood, in other cities. So unless we change, we cannot we will hope that such type of disaster will happen again. It is bound to repeat in India because executive don't do compliances. There are laws to make compliances, executive don't do compliances, and our attitude is सब चलता है, ठीक है नहीं किया चल जाएगा. We are not strict. We Indians forgive and forget. That we should not do. You cannot blame anybody for what is happening in India. It is ourselves to be blamed for it because we don't care about anything. We elect government, we choose people to rule us, they make laws, they govern India, but we don't react if they are doing anything wrong. Our reaction time is so slow in India. After 10 years, we will wake up. Some judgment is passed by Supreme Court 10, 15 years back. Then it will take ground after 10, 15 years. We will read about it ki kya hua hai. We don't read books. Newspaper is also not read so often. We are poor. What's happening around us? So nothing will change in India unless and until we change. Change is required in us. Change is required in the people who govern the system. A long time back it was said that we are giving very good constitution to India, but we are worried about the people who will use this constitution to run our country. It is for the people, if they are honest, they do their work diligently, they don't forgive and forget, so system will change. Only when system will change, things will change. And Bhopal gas tragedy, I still fear that tragedy. I have seen movies, but I was not able to complete any of the movies. I get so terrified seeing this. People dying on the road, inhaling gases, coughing, vomiting. And I have also seen a picture, very famous picture, and a photographer was also awarded a prize for it, a photo of a half-buried girl, and her face was there on all magazines and newspapers. So it was very terrifying what happened in Bhopal, but we have forget. So that is our nature. We forget and forgive. That we should not do. And what I think is to be done in future in India is we have to give first preferences to health, environment, and safety of people. That is our last preference in India. We don't care for our own lives. You get what you are. आपको वही मिलेगा जो आप हैं. आपको उससे ज़्यादा कम नहीं मिलेगा. आपको अगर अपने लिए कुछ चाहिए, if you respect yourself, then you will get respect. If you are negligent, you will get negligence. You will break law, you will get the same thing. तो आपको वही मिलेगा जिंदगी में जो आप हैं. अगर आप सब लोग चेंज होंगे जब भी कुछ चेंज हो सकता है. We don't wear helmets, not worried unless policeman will caught you and impose a challan on you, only then you will wear helmet. You will don't wear seat belts, not required. We are not worried. Abhi one of the important industrialist died because he was not wearing seat belt. We all of know he was traveling in such a big car, Mercedes car, not wearing seat belt. One doctor also died. So we are least worried about our safety. We should think of our safety first. We should wear. Uh, People also smoke in public. They are not worried about health of others. Adulteration is milk is there. Overuse of fertilizer everywhere. We are eating poison. We all are aware, but we are blindfolded. Unless you will not react, nothing will change in India. Same thing will happen again and again. Daily we are suffering the same things. Either it is bread, butter, milk, food. We are not worried what we are eating. I think worst quality of food is served in India. आपका जो खाना हम लोग खा रहे हैं, wheat we are growing, government is making no regulation, extra fertilizers they are putting, extra pesticides they are putting, we are all getting it. So things will only change, I say, when we will change, and our system will change if we'll work for that change, if we do our things in time, and we are disciplined, and our reaction time has to be very fast. If there is something wrong, we have to react it immediately, and we have to take a stand. We also don't take a stand if we see that something is going wrong. We don't take a stand. We are just passerby, see हो रहा है, चलता रहता है. And something same thing will happen to us only. कभी ये हमारे साथ भी होगा, आज हम दूसरों के साथ होता देख रहे हैं. So we have to take our stand. Our reaction time has to be very quick, good responses, and all blame comes to judiciary finally, because executive do not work. So PILs in court. So you cannot expect court to do the work of executive, but court is doing. You cannot expect court to, it is for the government and executive to work. But if they do, we face more litigations because each person is not doing their work. And you expect all the things to be done by court. So court is there to see the violations of law and to protect the rights of citizen. But now courts are having more reactive roles as public is not reacting. So it is for court is coming forward to protect them. Many new laws, many new cases are being, judgments are being delivered by courts. So we cannot expect that what happened in Bhopal gas tragedy, you blame courts that 40 years. So lawyers not arguing the case, witnesses not coming forward. If you see some incident and you are made witness, you yourself will not go to the court for giving witness. What court will do? They wait for the witnesses to come. We can only do what we have before it. What is the evidence before court? Court can only work upon it and deliver justice to the people. It is for the executive to gather the evidence. It is for the witnesses to come forward and give their witnesses in court. Only then court can deliver justices. Delay happens because witnesses are not coming forward. Summons are going, police are not serving it. Litigants, advocates do not want to argue the case. They want to keep the matter adjourned. So court can only work when all things are coming together and all of them are working properly. Then court can do. Only if we act fast, we read files very quickly. That is not the way that we will be able to deliver justice very quickly and fast. Vice Chancellor was telling what happened in India, how Anderson escaped. He never got punishment. Some Indians were punished 2 years, 3 years. Management was punished for Bhopal gas tragedy. So this will bound to happen. No witnesses are there. Management is asking for funds. No, they are not getting funds for doing safety works. Labor inspectors are not worried to take care of safety measures which is to be taken in the factory. Acts are there, Factory Act is there, Industrial Act is there, factory measures are there. But everyone has to act to make the things happen. Otherwise, I think not tragedy in such a vast scale as happened in Bhopal, but these smaller tragedies are happening in India. Every 6 months you will hear something. Maybe liquor tragedy, hooch tragedy. You had heard about cough syrups, then again aircraft crash. So all these are lack in precautions, safety measures, and our negligent attitude towards our own safety. We have to take care of our own safety. We have to point out wherever there is safety is lacking. Our reaction time has to be very quick. Whenever there is some fault, every citizen sees it, they have to make complaints. And they have to follow it also. You have to be active, only then things will change. Thank you. Thank you for listening me.
Thank you, sir, for your thoughtful reflection and gracing this occasion with your presence. May I now introduce our guest of honor, Honorable Mr. Justice Vivek Agrawal. Sir was born on June 28, 1967 at Kasganj in state of Uttar Pradesh. He began his legal practice at the High Court of Madhya Pradesh, where he handled a wide range of matters encompassing civil, criminal, and constitutional law. Through his dedicated practice, he earned recognition for his legal acumen and commitment to justice. Justice Agrawal was appointed as a judge of the High Court of Madhya Pradesh on April 7, 2016, and was confirmed as a permanent judge on March 17, 2018. During his tenure at the Madhya Pradesh High Court, he contributed significantly to the dispensation of justice and the development of legal jurisprudence across various fields of law. In acknowledgement of his merit and service, Justice Agrawal was transferred to the Allahabad High Court, where he took oath as a judge on October 17, 2019. He continued to serve with distinction, upholding the principles of fairness, diligence, and judicial integrity. The audience awaits your inspiring words, sir.
Honorable Shri Justice Pankaj Mittal Sahab, Judge Supreme Court of India and visitor of this National Law University Bhopal, Honorable Mr. Justice Vishal Dhagat, Judge High Court of Madhya Pradesh and Member Governing Council, Honorable Dr. Surya Prakash, Vice Chancellor, National Law Institute University Bhopal, Dr. Shri Krishna Rao, Vice Chancellor, Nalsar, Hyderabad, Professor Dr. K.V.S. Sarma, Vice Chancellor, NLUI, Assam, Professor Rashri, friend of mine, Professor and Head Government Law College, Bombay, Dr. Vijay Chaudhary, Member Bar Council of Madhya Pradesh, State Bar Council of Madhya Pradesh, Dr. Raka Arya, convener of this international conference, Professor Bakshi, Registrar, NLUI Bhopal, distinguished guests, learned participants, dear students, members of the print and electronic media, ladies and gentlemen. It is indeed an honor to be invited to speak at this international conference marking the 40th anniversary of the world's worst industrial disaster, the Bhopal gas tragedy, which unfolded on the fateful intervening night of 2nd and 3rd December 1984. It's a privilege to share my thoughts with this distinguished gathering. I take this moment not merely as an occasion to remember, but as a solemn duty to reflect, to remind, and to rekindle the collective conscience of humanity. That night, a night like any other, changed the course of history. As the city of Lakes slept peacefully, 27 tons of deadly methyl isocyanate gas silently escaped from the Union Carbide pesticide plant. Within hours, the streets of Bhopal turned into corridors of death. More than 4,000 people died overnight, and several thousands more were left battling for life and death. In the years that followed, over 5 lakh survivors have continued to live under the shadow of that invisible enemy, the gas that never truly went away. It was not merely a leak of gas, it was a leak of trust in science, in systems, and in safeguards. It was a catastrophe. I'm sorry for being emotional because I was part of this system. It was a catastrophe born of corporate greed, administrative apathy, and the dangerous illusion that safety can be compromised in the pursuit of profit. Even after 40 long years, the wounds of Bhopal have not healed. The soil remains poisoned, the groundwater is still contaminated, and the factory stands abandoned, a silent monument of neglect where children now play, unaware that beneath their feet lies the residue of human failure. The tragedy traces back to Union Carbide Corporation and American Chemical Company headquartered at Seadrift, Texas, now a wholly owned subsidiary of Dow Chemicals since 2001. The Bhopal plant, established in 1970s to manufacture the pesticide 7, was preparing for closing by mid-1984. Its safety protocols and equipments were reportedly far below the standards of its sister plant in West Virginia. MIC is a highly toxic chemical that causes. Then chairman and CEO of Union Carbide flew to India after the disaster but was allowed to return to the US due to political intervention. In 1992, the CGM of Bhopal declared him a fugitive. A formal extradition request was issued in 2003 and an arrest warrant followed in 2009. Union Carbide maintained that it had no operational role at the time, claiming the plant was managed by its Indian subsidiary and even suggesting sabotage. On June 7, 2010, 8 former employees were found guilty. The Government of India, acting as parents parenti for the victims, mediated a settlement. What Sir Surya Prakash said, brokered a settlement through the Supreme Court, accepting 470 million in compensation, a figure widely criticized for underestimating the long-term health consequences. According to the Bhopal Gas Tragedy Relief and Rehabilitation Department, compensation was awarded to 5,54,895 injured individuals and 15,310 families of the deceased. Several epidemiological studies conducted soon after revealed increased morbidity, mortality, chromosomal abnormalities, psychological trauma, and sensory impairments among the exposed population. In March 1985, the Indian government enacted the Bhopal Gas Leak Disaster Act to expedite claims and legal proceedings. Yet, amidst the horror, humanity rose to the occasion. Volunteers, including my own family, stepped forward to help. Medical aid poured in from across the globe. Mass cremations and burials were conducted. I was part to that. New Bhopal, a relatively less affected area, became a refuge. Food and medicines were distributed widely. A total of 337 tons of toxic waste was eventually incinerated at Pitampur, Madhya Pradesh. That too had its political and court battles. We had our heroes, like Mr. Ghulam Dastagir, Deputy Station Superintendent of Indian Railways at Bhopal, who at the cost of his life played a crucial role in saving many others by diverting trains and ensuring the Mumbai-Gorakhpur Express departed safely, sparing its passengers from exposure. His history is immortalized in the Netflix series The Railway Man. It's worth watch. Every person who is part of this conference should watch this series. I personally recommend that. Another milestone for the students of law, it was interim compensation of 350 crores granted in December 1987 by the district judge of Bhopal in a representative suit. Why I say it is an important milestone for law students, because we all are running for filing PILs in high courts and supreme courts. The mechanism of representative suit was first time was so effectively utilized in Bhopal, granting compensation of 350 crores to as an interim compensation. Some of the reasons for this disasters are lack of prioritizing economic growth, weak regulatory standard, industry lobbying, dereliction of duty, lack of public awareness. When we talk of dereliction of duty, it is most unfortunate that our judicial system failed to take cognizance of neglect of duty on the part of the officers of the state and the central government who were entrusted with the work of environment safety and industrial safety. This tragedy compels us to ask some uncomfortable but necessary questions. Where does responsibility truly lies? Is it with corporations that prioritize profit over people? Is it with the state which must ensure safety, vigilance and redress? Or is it with all of us as citizens, as institutions, as a collective humanity to ensure that never again does development come at the cost of human life and dignity? Eminent human rights lawyer once said, it is the memorialization and vigilance that ensure enforceability of the systems we have put in place to protect human beings. Indeed, the story of Bhopal is not frozen in history. It continues to echo, not merely as a memory of pain, but as a moral warning that laws without enforcement and policies without compassion are hollow promises. The road ahead, let this 40th year not be a mere remembrance of loss, but a renewal of resolve to strengthen our environmental laws, to make corporate accountability real and enforceable, to ensure that no other community, no other child ever breathes the air of injustice, to institutionalize mechanisms that prevent such disasters, to empower regulatory institutions with technology and most importantly, independence and moral courage, to streamline judicial processes for swift, affordable and holistic justice, and to uphold the right to life in its truest sense, the right to live with safety, dignity and hope. Let our legal system evolve to recognize the rights of victims and strengthen environmental jurisprudence. And let this conference remind us that the true development is that which preserves life, not endangers it. That the measure of civilization lies not in industrial might, but in our compassion, our vigilance, and our respect for human dignity. Because in the end, the greatest tribute to the victims of Bhopal is not in what we remember, but in what we resolve to never repeat. Yet, amidst this sorrow, Bhopal stands as a symbol of endurance, of survivors who refuse to surrender, of lawyers, doctors, journalists, jurists, and activists who refuse to be silenced, and of a city that, despite its scars, continues to live, to breathe, and to believe in the promise of a better tomorrow. As I stand before you today, I do so not as a historian, not as a storyteller, but as a proud son of Bhopal. One who has seen its tears and its strength, its tragedy and its tenacity. To err is human, but to learn is more human. Salutes to all the warriors of the Bhopal gas tragedy, survivors, volunteers and advocates for carrying forward the cause of humanity and justice. Thank you all for being an patient audience and being part of this day. Thank you.
Thank you, sir. And now, ladies and gentlemen, it is my honor to introduce the chief guest of today's inaugural session, Honorable Mr. Justice Pankaj Mittal, Judge, Supreme Court of India, and the visitor of NLIU. Sir was born on 17th June 1961 in Meerut into a family of lawyers, received his education at St. Mary Academy, Meerut, and graduated in BCom honors from the University of Allahabad in 1982. He obtained his law degree from Chaudhry Charan Singh University, Meerut, and enrolled with the Bar Council of Uttar Pradesh in 1985. Beginning his practice under Sri Sudhir Chandra Verma, who later became a judge of the Allahabad High Court and Lok Ayukt. Specializing in civil law, he handled numerous cases relating to land acquisition, rent control, education, labor, and constitutional matters, and served as standing counsel for UP Awas Evam Vikas Parishad and Dr. B.R. Ambedkar University, Agra. A third-generation lawyer and second-generation judge, his father, Justice Narendranath Mittal, served on the Allahabad High Court bench from 1978 to 1992. Justice Mittal was elevated as an additional judge of Allahabad High Court on 7th July 2006, later serving as senior judge of Lucknow bench, Chief Justice of Jammu and Kashmir and Ladakh High Court, and Chief Justice of Rajasthan High Court. He was elevated to Supreme Court of India on 6th February 2023. The gathering keenly awaits your enlightening address, sir.
नमस्ते, सभी को मेरा प्रणाम. My brother judges of the High Court of Madhya Pradesh, Dr. Shri Krishan Dev Rao, Vice Chancellor Nalsa, Dr. Surya Prakash, Vice Chancellor NLIU Bhopal, the other Vice Chancellor sitting here, foreign dignitaries, the convener of today's program, faculty members, and dear students. वंदे वाणी विनायको. बाबा तुलसीदास ने जब रामचरितमानस लिखा तो उसके प्रथम सोपान में उन्होंने वाणी और विनायक दोनों की प्रार्थना करी. वाणी जो हम बोल रहे हैं, जिस पे हमारा कंट्रोल रहना चाहिए, और विवेक हमारे इंटेलिजेंस, जिस पे हमें पूरा कॉन्फिडेंस होना चाहिए. इसलिए जब भी कभी मैं कहीं बोलता हूँ तो मैं भी बाबा की तरह वाणी विनायकों को ध्यान कर लेता हूँ कि मैं कॉन्फिडेंस से बोलूँ और अपने वाणी पे कंट्रोल करके बोलूँ. बहुत सी बातें कही गई. भारत बदल रहा है और हम नहीं बदल रहे हैं. ये विशाल भाई ने बड़े जोर से इस बात पे एम्फेसिस दे के कहा. हम महसूस करते हैं, समझ रहे हैं कि भारत बदल रहा है, और आज इस युग में तो हम क्लिक ऑफ बटन पे सारा काम करने की भी बात करते हैं. परंतु हम क्यों नहीं बदल रहे? जैसा विशाल भाई ने कहा, हम नहीं बदल रहे. उसकी वजह है हमने नैतिक शिक्षा को, मूल्यों पे आधारित शिक्षा को नजरअंदाज कर दिया है. हम जब तक नहीं बदलेंगे, जब तक हमें नैतिक शिक्षा नहीं मिलेगी और हमारे में एक डिसिप्लिन कायम नहीं किया जाएगा, हमारे चरित्र का निर्माण नहीं किया जाएगा. चरित्र निर्माण को हमने बिल्कुल साइड लाइन कर दिया है. हमारा कोई भी नागरिक चरित्रता की ओर ध्यान नहीं दे रहा है. उसी की वजह से सारे समाज में अराजकता दिखाई देती है और कोई भी डेवलपमेंट नहीं लगता. अब ये चरित्र निर्माण कैसे हो, नैतिक शिक्षा कैसे आए? तो एक छोटा सा, मैं बस ये डिसिप्लिन की बात है, उसके लिए कहूँगा कि हमारे अध्यापकों को उनकी छड़ी वापस दिला दी जाए. आज डिसिप्लिन समाज में आ जाएगा. नैतिकता लौट आएगी और चरित्र का निर्माण हो जाएगा। Now coming to the today's subject.
Sir, sorry to interrupt, आपने इनका दिल already जीत लिया है.
अरे सर, दिल जीत लिया होगा, लेकिन अब आगे बोर करने जा रहा हूँ. Now coming to the topic, I would say much has been said by the previous speakers. Dr. Surya Prakash has narrated the entire story, reminded you of the entire Bhopal tragedy. So there is nothing left for me to say, but still I will endeavor to read out to you my written text on the subject. Please bear with me and please don't get bored. I will be taking a little time anyway. The night of 2nd December 1984 remains a black mark upon the golden canvas of India's history. As the city of Bhopal slept, water entered into one of the underground tanks of the Union Carbide Corporation plant, which contained methyl isocyanate, triggering an uncontrollable chemical reaction. The pressure inside the tank soared past 200 degrees centigrade and the safety valves failed. Within minutes, a dense white cloud of gas began to pour out, spreading rapidly over the sleeping neighborhoods. The shanty towns located right next to the factory walls became the first to be consumed. People woke up coughing, their eyes burning and lungs collapsing. By morning, more than 3,800 people were dead. Later studies would estimate that the total deaths were over 15,000, with 500,000 more suffering injuries ranging from respiratory damage and blindness to neurological disorders. The contamination did not end that night. Toxic residues continued to seep into the soil and groundwater, poisoning the city's ecosystem for decades. Even children born years later were found to carry the scars of that night in their bodies, blood lines, and breath. What happened that night was not just an accident. It was the result of years' greed, as Justice Surya Prakash said, greed, carelessness, and dangerous faith in profit over people. At the heart of the tragedy lay a story much older than that single night, a story woven through policies, economics, and politics. A few years earlier, the Indian Parliament had passed a Foreign Exchange Regulation Act 1973, a law designed to tighten state control over foreign enterprises. FERA limited foreign equity in Indian ventures by not allowing them to exceed 50% ownership in the Indian corporations, and sought to ensure that the transfer of proprietary technology to Indian hands, paving the way for eventual nationalization. Yet, in the case of Union Carbide, an exception was made. The American giant was allowed to retain 50.9% ownership in Indian subsidiary on the grounds of introducing special technology. To maintain this privilege, Union Carbide Corporation cut the cost of construction from $28 million to $20 million, achieved by using cheaper materials and substandard safety mechanisms. Though Union Carbide Corporation claimed that the Bhopal plant met the same safety standards as its facility in West Virginia, there were many significant differences between the two. The American plant and the computer monitoring automatic shutdown systems and an emergency plan. The Bhopal facility had none of these. Workers repeatedly raised alarms about unsafe conditions through their union called the Union Carbide Kramchari Sangh, but their concerns went unheard. Cost efficiency triumphed over caution and negligence became routine. The factory premises in Bhopal was also tied to a broader story of green revolution. During the 1960s and the 70s, India and many developing countries adopted large-scale chemical-based farming to increase crop yields. This created a growing demand for pesticides which Union Carbide sought to meet. This created a growing demand for pesticides, and this revolution pushed thousands of small farmers off their land. Many of them migrated to cities like Bhopal, building makeshift homes near industrial areas in search of work. The government turned a blind eye, and soon densely packed slums surrounded the pesticide plant. Political leaders, eager for votes, distributed land title to residents near the plant without ever warning them of the danger next door. In short, the stage for disaster was set long before the gas even began to leak. Soon after, this chain of neglect and turned fatal on the night of 2nd December 84, which marked the beginning of decades-long tragedy that Bhopal was not prepared to face. The state was confronted with an extraordinary test of both law and governance. After the tragedy, hospitals overflowed with injured, yet doctors had no information on the gas, its antidote, or even basic protective equipment. Relief operations relied on improvisation rather than preparedness, revealing a total collapse of industrial and institutional safeguards. In all this, Union Carbide Corporation compounded the suffering by denying responsibility, blaming the Indian and the subsidiary, and concealing crucial chemical data. Even evidence of cyanide poisoning emerged, yet the company withdrew its own recommendation to administer the antidote, sodium thiosulfate, seemingly to avoid admitting that hydrogen cyanide had been part of the toxic mix. It was against this backdrop that the government of India initiated legislative measures to address the scale of disaster. In March 1995, Parliament passed the Bhopal Gas Leak Disaster Processing of Claims Act, granting Union government exclusive authority to represent all victims in legal proceedings. By invoking the doctrine of parens patriae, the parent of the nation, the state assumed the dual role of the legal guardian and trustee of its citizens. The idea was to prevent fragmented lawsuits and to ensure a unified pursuit for justice. Determined to hold Union Carbide accountable, the government filed a lawsuit in US court, hoping that stronger environmental and tort laws of USA would secure fairer compensation. But the American court dismissed the case under forum non-convenience, sending it back to India. When the case came home, the government became the sole litigant, representative, the negotiator of justice. While deciding this case, the Supreme Court applied the principle of absolute liability as laid down in MC Mehta in 1986. This principle recognized that industries engaged in inherently hazardous activities owe an unqualified duty to ensure that no harms befalls the community. Justice Mr. Surya Prakash has pointed out that this was a broker type of a judgment, and the compensation which was settled was just like a peanut. That may be a political or a very loud comment. I am avoiding all those things, but I am just reminding what Dr. Surya Prakash has said. It was a visionary principle, the principle of absolute liability, born out of India's own experience with industrial catastrophe, and it placed moral responsibility squarely on those who profit from risk. However, in the Union Carbide case, this very same principle did not find full reflection in the outcome. The approved settlement of 470 million US dollars, though intended to provide swift relief, when viewed in retrospect and against the magnitude of loss, appears inadequate to the scale of suffering. The settlement also brought an unfortunate end to the then ongoing criminal proceedings, hence effectively insulating key corporate officers from personal accountability. Furthermore, Warren Anderson, the head of the Union Carbide, remained beyond the reach of justice until his death in the year 2014, leaving the proceedings against him unresolved, serving as a stark reminder that justice delayed can sometimes be justice denied. The story of Bhopal cannot be told in isolation. It belongs to a lineage of industrial disasters that collectively map humanity's uneasy tryst with technology, profit, and law. Each tragedy, Minamata of Japan, Seveso in Italy, Bhopal in India, followed by Chernobyl of the Soviet Union, was not merely a local failure but a chapter in a shared global reckoning over the limits of industrial civilization. In Minamata, Japan, during the 50s, mercury discharged by the Chizo Corporation contained local waters, poisoning thousands through the food chain. The victims were primarily fishermen and their families who suffered irreversible neurological damage, a condition known as Minamata disease. For years, both the corporation and the government denied responsibility, manipulating scientific data to evade liability. Only after decades of protest did Japanese courts in the Minamata Disease Corporation case 1973 hold Chizo liable and recognize the victim's right to redress. The struggle became a turning point in Japan's environmental law, leading to the basic law for environmental pollution control and embedding environmental rights within Japan's post-war democracy. It can be said that Mimanta's case gave the world a voice for environmental victims. Sivaso offered a blueprint for prevention. Chernobyl warned against capacity and complemency in high-risk technologies, and Bhopal posed the enduring question: can law truly civilize industry before industry exhausts the moral patience of law? Viewed together, these disasters chart the moral geography of industrial modernity. Each exposed the same contradiction that progress without precaution is peril and development without dignity is regression. Yet their legacies diverged. Japan and Europe responded with robust legal architectures and corporate liability regimes, while India's response, though visionary in doctrine, often faltered in enforcement, constrained by institutional inertia and fragmented governance. Now, this gave rise to the environmental jurisprudence. It was in the wake of these global lessons that the Indian Parliament and the judiciary embarked on a transformative reinterpretation of law and responsibility. Bhopal gas tragedy compelled a fundamental rethinking of the relationship between industry, the state, and the citizen, transforming environmental protection from peripheral regulatory concern into constitutional imperative. The first response came from the judiciary itself. In MC Mehta, this opium gas leak case of 1986, a decisive moral departure from the old English rule of strict liability came. The Supreme Court articulated the doctrine of absolute liability. Justice Bhagwati held that enterprises engaged in inherently hazardous activities owe an absolute and non-delegable duty to ensure that no harm results to the community. Unlike the English doctrine of strict liability under Rayland versus Fletcher, which permitted defenses such as acts of God or third-party negligence, the Indian doctrine admitted no such escape. This shift marked the beginning of what scholars later termed India's green constitutionalism. As part of this pioneering shift, Supreme Court then read environmental protection into Article 21, transforming the right to life into that of right to clean, safe and sustainable environment. Subsequently, Parliament enacted the Public Liability Insurance Act 1991, which institutionalized the idea that those engaged in hazardous industries must internalize the cost of potential harm. For the first time, enterprises were required to maintain insurance policies capable of providing swift, no-fault compensation in the event of an industrial accident. Though limited in scope and cramped in quantum, this enactment represented a vital shift from reactive justice to preventive accountability, from crisis-driven response to preemptive preparedness. Though in the 1990s, the environmental jurisprudence further matured into a comprehensive legal philosophy, in Vellore, Citizens Welfare Forum, Supreme Court formally adopted the principle of polluter pays and precautionary actions, integrating them into Indian law as essential elements of sustainable development. The court emphasized that environmental protection and economic growth were not opposing goals but complementary duties, and that polluters must bear the social cost of their activities. Later, the same year, in the Indian Council for Environmental Legal Action, the court reinforced the stance of directing actual remediation and restitution, holding that environmental degradation is not merely a statutory violation, but a constitutional offense against the collective right of life. Together, these decisions transformed environmental protection from a moral appeal into a matter of enforceable legal accountability. Furthermore, the Parliament enacted the National Green Tribunal Act 2010, creating the National Green Tribunal as a specialized forum for expeditious, expert-led adjudication of environmental disputes. The NGT embodied India's transition from ad hoc judicial activism to structured environmental governance. It operationalized the principles of sustainable development, polluter pays, and precautionary action within the technical and the quasi-judicial framework. Parallel to these developments, Bhopal gas tragedy also catalyzed a deeper administrative awakening. The tragedy had exposed not only the inadequacies but also the absence of coordinated disaster response. This recognition culminated in the Disaster Management Act of 2005, which sought to establish a structure architecture for preparedness and response through national, state, and district level authorities. The Act sought to institutionalize planning, coordination, and community participation as pillars of national resilience. The evaluation of environmental law in India stands not only a response to past tragedies, but as a living promise that development in this country shall never again come at the cost of human dignity or environmental integrity. Now, what are the recommendations I make after this tragedy or the lessons we learned from this Bhopal disaster? However, the discussion on the subject would remain incomplete without pondering upon the potential reforms. The lessons of Bhopal compel us to move beyond reactive justice towards institutional foresight, to craft systems that prevent tragedy rather than merely respond to it. The foremost lesson from Bhopal is the urgent need of an authority such as National Industrial Disaster Relief and Compensation Authority. Because somebody said that there is no mechanism of determining the compensation. Under the Motor Vehicles Act, the Workmen Compensations Act, we have a particular type of a system. But for industrial disasters like this, we have no. A statutory mechanism capable of ensuring immediate medical and financial assistance, independent of scientific assessment, and transparent fund management. This would transform compensation from a discretionary gesture into a legal entitlement, ensuring that those who suffer industrial harm are not left to navigate a maze of bureaucracy and delay. In this regard, India's Civil Liability for Nuclear Damage Act 2010, after a comprehensive precedent, serves as a comprehensive precedent. It established a tiered liability framework where operators of nuclear installations bear no fault liability, backed by government support and an insurance pool. The Act reflects as an acknowledgement that large industrial risks require preemptive financial preparedness and an immediate compensation mechanism. Drawing on such principles, a comprehensive industrial disaster framework could extend similar foresight beyond the nuclear sector, ensuring that justice is not contingent upon litigation but flows automatically from industrial design. Bhopal was not only a legal or a cooperative failure, it was a planning failure. We should not allow companies to set up hazardous industries in our country. If at all it is required, hazardous industries should not be permitted without rigorous and transparent environmental security. The proximity of hazardous industries to densely populated settlements magnified the human cost. Future policy must mandate hazardous units be located only in designated uninhabited industrial corridors with adequate buffer zones and strict environmental oversight, and that no settlements or habitants should be allowed to settle around these industries. Thirdly, the corporate accountability must evolve from an ethical duty into an enforceable legal standard. Bhopal revealed how multinational corporations exploit fragmented liability to escape responsibility. Strengthening India's framework for corporate and managerial liability, especially through non-delegable duties of care and mandatory environmental insurance, is essential. Borrowing from international models like the UK Corporate Manslaughter Act, the Indian law must hold corporations criminally and financially liable for systematic safety failures. Transparency through public safety audits and real-time compliance reporting would ensure that profit never again precedes precaution. True accountability means embedding consciousness into corporate structure so that no enterprise can externalize its cost onto human life. As we draw this address to a close, we return to the truth that has echoed through every part of this discourse. When dharma is neglected, when moral responsibility is forsaken in pursuit of profit and convenience, even the strongest laws lose their force. The Mahabharata reminds, Dharmo rakshati rakshati, dharma evam hato hanti. When dharma is protected, it protects. When destroyed, it destroys. Bhopal stands as an embodiment of this truth. It reminds us that justice and governance rest not only on statutes and institutions, but on conscious and invisible thread that binds duty to humanity. In the end, Bhopal was not merely a technological failure or a legal misfortune. It was a moral reckoning, a collapse of ethical responsibility across every level of governance and enterprise. It revealed how, in the absence of accountability, industrial progress can turn predatory. The tragedy of Bhopal is therefore not confined to history. It is continuing warning, a reminder that development without safeguards and profit without responsibility can exact a price no society should ever again be asked to pay. As we convene here at this international conference, let us not merely recount the past, but renew our collective pledge for the future. Let the memory of Bhopal endure not as a tombstone of sorrow, but as a living constitution of consciousness, guiding institutions, shaping governance, and defining the moral character of our shared humanity. To remember Bhopal is to act, to reform, to safeguard, and to ensure that the duty to remember remains inseparable from the duty to protest. Only through such vigilance can the tragedy of Bhopal transform from a symbol of loss into a lasting mandate for justice, for responsibility, and for the sanctity of human life. Jai Hind. Thank you.
Thank you so much, sir, for your illuminating words that truly enrich our understanding and reaffirm the importance of law, compassion, and responsibility in our collective conscience. To express our gratitude, may I now request Shri Vivek Bakshi, Registrar, NLIU, Bhopal, to kindly deliver the vote of thanks.
Good morning. The tragedy, Bhopal gas tragedy that we are discussing today, and we have heard legal luminaries, Justice Pankaj Mittal Sahab, Justice Vivek Agarwal ji, Justice Vishal Dhagat ji, and our own Vice Chancellor Sahab, Dr. S. Surya Prakash, Dr. Sri Krishna Dev Rao, and Raka Ma'am. So the tone for the event is set, and we hope that the event will continue in the same spirit. As Vivek Agrawal sir was saying, I also have a personal connection with Bhopal. I was not here at the time, but if you see the changes that has come, just for the prospective sake, for the younger generation to know, there was no internet, there was no mobile, and my uncle was working in BHL, so they were residing in this Govindpura area itself. We were worried about the welfare of the family. So there was only one way to communicate. You have to have an STD phone. And it was so difficult. We also shot one telegram. So you can understand the difference that has come over the years. But still, as Dhagat Sahab has said, people who are caught unaware, MNCs will do the predatory pricing. If you give them a chance, they will exploit you. So we need to be on our own guards. We need to be careful that we are vigilant as for our society, our family, and our nation. And I welcome you all, the faculty members who have come from different parts of the country, even abroad. And we hope that you have a pleasant stay at campus. I welcome you all. Thank you.
Thank you, sir. Ladies and gentlemen, please rise for national anthem.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे, तव शुभ आशीष मांगे, गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
Please be seated. With this, we come to an end of our inaugural session. We thank all our distinguished dignitaries, esteemed guests, and participants for joining us this morning. Please join us for the tea break. From 12:30, we will commence our next session at Rajiv Gandhi National Cyber Law Center. I request you to reach there by 12:30. Thank you.